Before you worry, let me gently reframe what is happening because the law itself is not brand new at all. The federal statute sitting at the center of this story is called 31 United States Code Section 5324, which is the part of the Bank Secrecy Act that makes it a federal crime to break up one larger financial transaction into several smaller ones for the specific purpose of dodging the federal reporting requirements, and that provision has been on the books since 1986. The companion statute is 31 United States Code Section 5313, which has required United States banks to file a currency transaction report, called a CTR, for any cash deposit, withdrawal, exchange, or wire transfer over $10,000 since the same year. What changed in January of 2026 is not the wording of either law, and it is not a new Congress passing a brand new rule. What changed is the number of federal agencies now permitted to read each other's filings about you and what they decided to do with that information when they see a senior on a fixed income moving money home in the exact pattern that the statute was written to catch today. Now, here is the part of the story that surprises almost every senior sitting in their kitchen with their coffee this morning. Because the dollar amount that the new enforcement setup treats as suspicious is much, much smaller than the $10,000 figure almost every immigrant has been warned about for years. Under the new Memorandum of Understanding that the Social Security Administration signed with the Department of Homeland Security, the Financial Crimes Enforcement Network, and United States Citizenship and Immigration Services, a pattern of 3 or more wire transfers of $3,000 or more from a Social Security benefit recipient in any rolling 90-day period now triggers an automatic structuring alert inside a federal database called the Bank Secrecy Act Portal, the BSA Portal, which is the filing system maintained by FinCEN under its authority in 31 United States Code Section 5311. The reason $3,000 is the magic number fear now hangs on is that 3 remittances of $3,000 each add up to $9,000, which sits just $1,000 below the $10,000 currency transaction report line that almost every immigrant in America has been carefully taught to stay under since they first opened a bank account at the local credit union. That $1,000 buffer used to feel like the safe harbor that their cousin told them about and their uncle relied on. That buffer is no longer a safe harbor in 2026. If you have heard me say for years that $10,000 in wires is the federal magic number, that advice was correct in 2024 and 2025, but it is no longer correct in 2026 because federal investigators are now using pattern detection software that looks at your full transaction history and not just one day's wire transfer, which means you can stay below $10,000 on every single transaction and still raise a structuring alert today. Let me walk you gently, in plain English, through how a senior's Social Security record actually travels from a benefit check all the way to an immigration file sitting on a federal officer's desk in 2026. The path begins at the Social Security Administration, which is the agency that decides whether you get a retirement check, a survivor benefit, or a disability check each month, and which keeps a master record of your direct deposit bank account, your mailing address, and your Social Security number today. The second stop on the path is your bank, which under 31 United States Code Section 5313 must file a currency transaction report, called a CTR, with FinCEN anytime you move $10,000 or more in cash or wire in one day, and which also files what is called a Suspicious Activity Report, called a SAR, anytime a bank officer notices a pattern that looks like 31 United States Code Section 5324 structuring, even when no single transaction ever crosses the $10,000 line today. The third stop on the path is the Financial Crimes Enforcement Network itself, which is the bureau inside the United States Treasury Department that collects every CTR and SAR, runs them through the BSA portal, and under the 2026 Memorandum of Understanding, now passes certain alerts forward to the Department of Homeland Security and to United States Citizenship and Immigration Services on the same business day today. The fourth stop is the Department of Homeland Security, which is the cabinet-level agency that houses three of the federal offices that decide your immigration life, namely United States Citizenship and Immigration Services, which processes your green card and naturalization paperwork, Customs and Border Protection, which logs your entries and exits at the airports, and Immigration and Customs Enforcement, known as ICE, which is the agency that brings removal cases today. The fifth stop is your own United States Citizenship and Immigration Services A file, which is your master immigration folder kept in a federal records center, and where a single structuring alert from FinCEN is now attached as a side note next to your Form Y-130 Family Petition, your Form Y-485 Adjustment of Status Application, your Form N-400 Naturalization Application, or your Form Y-751 Petition to remove conditions on residence, depending on which stage your case sits at this very moment in 2026. That is how a mother sending $3,000 to her daughter in Manila every 2 months can find, without any warning letter, that her naturalization interview has been quietly pushed back by 7 months while a USCIS officer runs her BSA portal data. That is how an older brother sending 2 payments to a nephew in Hanoi can find that his Form 1751 joint petition has been flagged with a code the lawyer has to look up. None of these agencies are required to send you a courtesy notice under the Memorandum of Understanding signed in January 2026, and that silence is the part of the system most seniors do not understand, and most predators in suits already understand today. Let me introduce you to a real person whose situation mirrors tens of thousands of households across this country, and I will use her name and her full details because stories told without a name do not stick in your memory the way they should today. Maria Esperanza Gutierrez is 67 years old, a lawful permanent resident originally from San Miguel, El Salvador, who came to the United States in 2002 under a family petition her sister filed, and who worked for 21 years as a certified nursing assistant at a long-term care facility in San Antonio, Texas, before she retired on her own Social Security retirement benefit at 62 today. Maria today collects $1,540 a month in Social Security retirement, $640 a month in supplemental security income she applied for last year, and she rents a 1-bedroom apartment in a small complex on the south side of San Antonio for $970 a month today. Her husband passed away in 2016, she has diabetes, she qualifies for Medicare Part A and Part B. Since 2020, she drives a 2012 Toyota Corolla with 145,000 miles on it, and she has never filed a FinCEN Form 114, also called FBAR, because her only foreign account is a small savings account her mother left her in San Miguel today. Her daughter Carmen lives in San Salvador with 3 of Maria's grandchildren. Carmen works as a seamstress in a small shop that closes when work is slow, and beginning in February of 2025 and continuing like clockwork through December, Maria walked into the same branch of her credit union every 2 months, waited in line, and wired $3,000 to Carmen through a wire service today. 3 wires in February, 3 wires in April, 3 wires in June, 3 wires in August, well over the 3 transfers in any rolling 90-day window called for by the new Memorandum of Understanding I just described today. None of those wires hit $10,000. None of those wires was a single cash transaction she was hiding, and Maria was not trying to do anything wrong. She was just trying to put food on a grandchild's table in El Salvador today. In June of 2026, Maria received an appointment letter in the mail from United States Citizenship and Immigration Services, scheduling her naturalization interview, and the interview was preceded by a strange note on her case file that she could not read because it was written in agency codes today. The officer asked her on the record about her remittance history, and she answered honestly, and her Form N-400 was continued, which is the legal word for postponed, for an additional 18 months of financial review, a length of time that forced her to renew her green card twice more before the case unstuck today. Let me introduce you to a second senior whose situation looks almost the same on paper but who sits in a very different corner of the immigration system. And you will see in a moment why the dollar math is identical, but the legal exposure is doubled today. Wei Lin Chen is 71 years old, a lawful permanent resident originally from Taipei, Taiwan, who immigrated to the United States in 1991 under an immigrant visa, who built a small computer repair business in Alhambra, California, and who retired 2 years ago on a Social Security retirement benefit of $2,100 a month after he sold the business to his nephew for a down payment plan that has not finished paying out yet today. Wei Lin today lives alone in a condominium his younger brother helped him buy in 1996, drives a 2014 Honda Civic, takes a cholesterol pill each morning, and qualifies for Medicare Part B and a Medicare Advantage plan through a major insurer in Los Angeles County today. His only son, Daniel, lives in Taipei with Daniel's wife and their 2 children. Daniel runs a small tea shop that has been quietly losing money for 2 years, and beginning in March of 2025, Wei Lin wired his son money every month, $2,900 at a time, by going to the same branch of his bank in downtown Alhambra and filling out the international wire form in person because he prefers the paper receipt he can show his son on WeChat each time today. By November of 2025, Wei Lin had sent 9 separate wires, all of them just under the $3,000 mark his cousin had warned him about years earlier, all documented carefully, none of them designed to do anything except help his grandkids with school uniforms and winter coats today. Wei Lin also holds dual citizenship in the sense that his Republic of China passport never expired and that he renewed it through the Taipei Economic and Cultural Representative Office in Los Angeles in 2024 without telling anyone in his United States immigration case about it today. When Wei Lin filed his Form N-400 naturalization application in February of 2026, he answered the question about continuous residence and the question about foreign travel honestly, but he did not attach a disclosure of the renewed Taiwanese passport because the form did not seem to ask him in plain English today. In April of 2026, United States Citizenship and Immigration Services sent Wei Lin a request for evidence under 31 United States Code, Section 5324, asking him to prove that his remittance pattern did not constitute structuring, and a separate request for evidence under INA, Section 101F, the Good Moral Character Clause, asking him to explain his unreported foreign citizenship status, and his Form N-400 is now sitting in a holding pattern at the California Service Center, while his family wonders whether he will be a United States citizen in time to attend his granddaughter's wedding next spring today. Here is the part of the system that catches most seniors by surprise, and it is the single biggest reason you cannot treat your immigration interview like a regular conversation at the bank today. Under the Immigration and Nationality Act, the federal statute that drives every visa, green card, and naturalization decision in 2026, the burden of proof in immigration proceedings sits on the applicant, not on the government, and this is the complete opposite of how the criminal justice system has worked since you were a young person today. In a United States criminal courtroom, the prosecutor must prove guilt beyond a reasonable doubt, which is the highest standard in the entire federal court system, and the defendant does not have to say a single word today. In a United States immigration proceeding under INA Section 240, which is the statute that governs removal hearings, or under 31 United States Code Section 5324 in the Parallel Financial Review, the applicant must prove that they deserve the benefit they are asking for, must prove every negative, must bring every document the government might want to see, and must convince the immigration officer or the immigration judge that no statute bars their case, all on their own today. The federal statute that gives the government this power is INA Section 240, the removal statute, which says that the respondent, which is the legal word for the person facing removal, has the burden of establishing that they are lawfully present in the United States and entitled to remain today. The companion statute is INA Section 245, the Adjustment of Status statute, which places the burden of proving admissibility on the applicant, not on the government today. The long list of inadmissibility grounds, including fraud and willful misrepresentation, sits inside INA Section 212A, and the applicant must affirmatively disprove every single one of them today. None of these burden of proof rules require the government to prove anything negative, and none of these rules require the government to warn you in advance that your bank record will become evidence at your interview today. Now let me tell you about the people who will try to take advantage of the fear I have just described, because they have already started, and I want you to recognize their voices on the phone before they recognize you today. In 2026, there are three kinds of predatory consultants watching this same news for the same reason you are watching it today. The first kind is the licensed immigration consultant who is not actually a lawyer, who advertises on Spanish-language radio, who says they can fix a structured transaction finding for a flat fee of $2,500 to $8,000, and who hands you a fake good moral character letter on fancy letterhead that does absolutely nothing inside the BSA portal today. The second kind is the notario, which is a Spanish-language term for a non-lawyer who offers immigration services without being licensed to practice law in your state, who charges $500 to $3,000 in cash, who talks very fast, who says everything will be fine, and who disappears the moment USCIS sends a request for evidence to the address on file today. The third kind is the worst kind in 2026, and that is the immigration tax specialist who calls you on the phone, who quotes the Financial Crimes Enforcement Network reporting thresholds incorrectly, who sells you a Form 105 filing service that has nothing to do with structuring defense, and who keeps your original Social Security award letter as collateral until you finish paying today. The most important lesson to take away from the 2026 marketplace is this. A real licensed immigration attorney will always give you a written engagement letter, will always give you a bar license number from a specific United States state, will never guarantee an outcome in writing, and will never ask you to hand over original government documents you cannot replace today. A notario will not do any of those four things, and will quite likely do none of them today. The State Bar of California, the State Bar of Texas, the State Bar of New York, and the corresponding authorities in every other state maintain a public lookup tool you can use today to confirm whether the person sitting across from you is actually a licensed attorney or merely someone who can speak fluent immigration jargon without a license to back it up today. The United States Citizenship and Immigration Services website also publishes, in 2026, a directory of nonprofit legal service providers known as recognized organizations that offer free or sliding scale help to seniors on Social Security, and the Legal Services Corporation funds a national hotline at 1-8003-540365 that connects callers over 60 years old to accredited representatives today. If someone asks you for cash before they will even look at your case, hang up the phone today. If someone tells you they can erase a structuring alert from the BSA portal, hang up the phone today, because no private consultant has access to FinCEN's portal in 2026, and any claim to the contrary is a lie today. Now that the law and the enforcement and the dollar number and the case studies and the consultants are on the table, let me give you the action plan, and I will walk through it the way a friend would walk through a recipe in a kitchen, one step at a time, in plain English, with no jargon in the way today. There are 7 specific actions you should take starting this week, and I will name each one as a plain named step so you can write them on a single page and tape the page to your refrigerator today. Step 1 is the written log. Pick up a small notebook, a single sheet of paper, or a single computer spreadsheet, and keep one row for every wire transfer you send out of the United States starting today. Write down the date, the amount in dollars, the recipient name, the recipient country, the bank or wire service you used, the receipt or confirmation number, and the purpose of the wire in one plain English sentence today. That single notebook is the most important piece of protection you can build for yourself in 2026 because it gives you a contemporaneous record an immigration officer can hold in their hand and read at your naturalization interview today. Step 2 is the voluntary disclosure. If at any point in 2026 the total of all your wire transfers to a single recipient crosses the $10,000 line in a calendar year, file a FinCEN Form 105 voluntarily before anyone asks you to file it today. The Form 105 is the International Wire Transfer Report, and a voluntary filing is treated far more gently by FinCEN, by the Internal Revenue Service, and by United States Citizenship and Immigration Services than a filing the government demanded after an audit, and that difference in treatment was reaffirmed by Treasury Department guidance in 2025 today. Step 3 is the no-split rule. Stop breaking up large transfers into smaller transfers to stay under the $10,000 line today. If you need to send $10,000, send $10,000. The old advice to break it up was wrong in 2024, and it is even more wrong in 2026 because every additional transfer below $10,000 adds to your structuring pattern in the BSA portal and increases the chance of an automatic structuring alert being attached to your A file today. Step 4 is the licensed attorney. Find one licensed immigration attorney in your state through the State Bar Lookup tool. Ask for a 30-minute paid consultation. Bring your written log from Step 1 and ask for an honest written opinion about your specific case today. A real attorney will give you their bar number on the business card. A real attorney will not guarantee an outcome. A real attorney will tell you what they do not know. And a real attorney will not disappear when the request for evidence arrives today. Step 5 is the direct deposit check. Call the Social Security Administration at 1-800-772-1213. Confirm that your direct deposit bank account is in your name, and make sure that the bank account on file matches the bank account from which you make your wire transfers today. A mismatch between your SSA direct deposit bank and your wire transfer bank is one of the top 3 triggers that produces a structuring alert in the BSA portal in 2026 today. Step 6 is the foreign account filing. If you have any foreign bank account, any foreign brokerage account, or any foreign pension account that held more than $10,000 at any point in 2025, file a FinCEN Form 114, also known as the Report of Foreign Bank and Financial Accounts, or FBAR, by the April 15th deadline in 2026, and let your immigration attorney know that you filed it so the disclosure shows up in your A file today. Step 7 is the sponsor conversation. If your son, your daughter, your brother, or your sister signed an affidavit of support, which is Form Y-864 in the United States immigration system, on your behalf at any point in the past, sit down with that sponsor this week and tell them the truth about your real income, your real remittance pattern, and your real household finances before the immigration officer asks the sponsor the same questions at your interview today. If you can do all 7 of those actions this month, you have done more than 95% of the seniors in your situation have done, and you will walk into your next immigration interview with a paper trail an officer can read in 5 minutes and a story that holds together today. What I want you to take away from this entire video is that the fear I have described is real, that the dollar number is smaller than you expected, and that the people who will try to scare you are already at work tonight today. But fear does not have to be the ending of this story. Preparation is the ending of this story today. The moment you have a written log, a voluntary disclosure on file, a real attorney on the phone, and a sponsor who knows the truth, you have done what the federal agencies hope almost no senior will ever do, because almost no senior will ever do it. And that single act of preparation is what separates a renewal that takes 18 months from a renewal that takes 11 months in 2026 today. I do not want you to feel panicked by what I have just shared with you. I want you to feel respected. Because the truth is that hundreds of thousands of seniors just like you have been quietly moving money home for years, doing it from the heart, doing it without intention to break any law. And most of those seniors will end up exactly fine because they take the kind of simple steps I just walked you through today. Preparation is not panic. Preparation is power. And the seniors who take these steps in 2026 are going to be the seniors who walk into their naturalization interview next year holding a single notebook that explains their entire financial life in plain English today.